Take this off. Haha. Okay, good morning, everyone. Welcome, welcome. Today it is October 22nd. It is 10 o'clock. We are in the town of Fort Myers Beach. My name is Nancy Stuparich, and I am a attorney with the Vos Law Firm. Our firm is located in Winter Park, Florida. We have the privilege and the honor. We are so happy to be able to work with the town of Fort Myers Beach and represent the town as their town attorney. And I am the lucky that I get to come. But there are other attorneys in our firm, so you may see them periodically. So welcome. Today we're going to spend probably an hour or so, and we're going to be talking about the Sunshine Law, the Public Records Law, as well as some ethics law that you as a member of an advisory board are subject to. So before we get started, I kind of told you who I am. Maybe you already knew. So I just want to go around the room real quick and kind of get to meet you, and also to know what committee or board or commission that you represent or that you were appointed to.
My name is Ellen Vaughn, and I'm a member of CELCAB.
My name is Sharon Hegstrom, and I'm a member of the MRF committee.
My name is Dave Nussbaum, and I'm also a member of the MRF committee.
How you doing? Ron Benak, and I'm on Public Safety Committee.
I'm John Deslier, and I'm on the BORCAB committee.
Todd Capella, Public Safety.
And I'm sure that we have a lot of members of our community watching. It's always good to have a refresher. Once you learn the basics of these three statutes, you kind of get it, but it's always good to have a reminder. In fact, we have a couple people that are both on the same board, and so we'll be talking about that specifically today as far as what your obligations are as members of the same board. So with that said, I'm going to go ahead and get started. I'm not really good at lecturing, but I do talk a lot. So if you feel the need to interrupt me and have a question, I welcome that. So if there's anything that I say that is not clear, just go ahead and put your hand up, and I will stop and I'll address it, and then hopefully I'll get back on track and we'll finish up the presentation. So Josh just got me set up here. Maybe he doesn't. Josh, did I mess up already? There we go. Okay. So again, just to kind of go over what we're going to talk about. And by the way, how many of you have went to the last training session that we had? So 3, 4. Okay. So again, this will just be a refresher, hopefully. So the first thing we're going to talk about is government in the sunshine. This is the open meetings law, always called sunshine law. Public records law, and then just a couple of the sections of Chapter 112. There's other sections. Chapter 112 deals with all public type employees, but we're going to focus on the sections that might impact you or that you might run across, including voting conflicts, the misuse of your public position and information, the solicitation and the acceptance of gifts, and also whether or not you need to fill out the Form 1 because it is now required to be completed online. So with that said, let's go ahead and get started. First, we're going to talk about the Sunshine Law. It basically provides that there is a right of access to the public to come and observe your meeting, which means all public business is going to be done in the sunshine, right? The state of Florida, sunshine. And this applies not only to our elected town council members, but also to you as members of the appointed boards. So again, the general rule when people talk about sunshine is that any meeting at which official acts are taken or where public business is talked about has to be in the open and has to be noticed to the public. So again, this applies to any type of meeting, and meeting is kind of broadly defined. And this is between 2 or more members of the same board, which is what I pointed out. We've got 2 members of MRF and 2 members of public safety here today. So the Sunshine Law applies to you today. When discussing matters that may foreseeably come before your board. So there's no violation of the Sunshine Law, the fact that you're both at the meeting. It's if you sit next to each other, which we have, hint, hint, but don't talk about anything that's going to come before your board. Okay? Now, what is a meeting? So meeting is broadly defined. It can be an official board meeting and a workshop, or it could be in the form of a telephone call or text messages. It could be in the form of emails or other correspondence. And the discussion could be informal. It's not like you two happen to be sitting next to each other and it's like, okay, I'm on the committee. Yeah, you're on the committee. Let's have a little meeting here. No, it doesn't work that way. It's just casual conversation between the 2 individuals. So there's 3 requirements for having a public meeting. The first is that it has to be open to the public. Is this room open to the public? Yes. Yes, it is. We have a door, which probably should be open, but we have staff, there it goes, see, they opened it for me. But we have staff members outside that will into the meeting room. Josh, am I messing this up? No, okay. Getting trained on this mic. Reasonable notice, the meeting itself. And what does that mean? Well, what is reasonable under the circumstances? So for today's meeting, our town clerk, she did advertise it. It is on the website. That's pretty reasonable. People that are interested would know. I think you all also received an email advising you and reminding you that today we had this meeting. Minutes taken as well of the session. So Amy, as your town clerk, she will be responsible for taking minutes. The same guidelines that we just talked about applies to your, oh, okay, don't hold it so close. The same guidelines that we're talking about applies to your individual board meetings as well. So basically, you have to have your meeting in a place that's publicly accessible, okay? And you have to give people notice, but for your individual meetings, the town clerk will notify. And also, I don't know if Amy, if you do you take, or do they take the minutes?
We record all the meetings, and then we have an off-site transcriptionist that creates the minutes.
So, and just a brief mention about minutes. It's not required that they be verbatim minutes. If you do want verbatim minutes, oftentimes those are done in a quasi-judicial, when we get a little bit more formal on land use decisions. There will be a court reporter that's present and will take verbatim. With technology now, it is easier to do a little bit more detailed on the minutes, but they can be summary minutes, but there has to be minutes, okay? All right. Okay, so this is, this gets to the scope of what your duties and responsibilities are. So you might think, we're just an advisory board, we just do recommendations. We're not the final decision makers. It doesn't matter. You're part of that decision-making process that the public has the opportunity to be aware of and to ultimately be involved in. So basically, if you, as an advisory board member, you are subject to the sunshine, even though your recommendation is not binding upon the town council. So here are all the advisory boards that we have in Fort Myers Beach. We have the Anchorage Advisory Committee, we have the Audit Committee, we have BORCAB, CELCAB, the Local Planning Agency, we have MRF, we have a Nuisance Abatement Board, which hasn't met in a while, we have the Public Safety Committee, and we have a brand new committee that is of limited duration, which is the Town's Charter Review Commission. So meetings with staff. So as a member of the advisory board, you do have the opportunity to contact staff for more information to make your meeting more meaningful. So the meeting that you have with staff is not subject to the Sunshine Law. And the reason for that is because staff is not a member of your committee. So Sunshine applies between members, not between members and staff. But there's an exception to that, and that's when the staff member stops performing in the capacity as staff and then has some kind of authority to work with that committee. I don't think we have any examples. I'm going to defer to Amy a little bit during our presentation today because she does a lot of the nuts and bolts of the day-to-day activity with the advisory boards, but I don't think we have anybody staff member that has been put on a committee.
We don't.
Yeah. But if we did, then they would be subject to the Sunshine Law. So I think that they are, he would not be staff, but he's ex officio. So, okay, so moving on. Okay. So we talked about the different types of meetings. So advisory board members cannot use email or telephone calls to conduct a private discussion about board business. You can send what's called a one-way communication to each other as long as the communication is kept as a public record and there's no response. So the example of that, to put it in really regular English, right? Not this legalese stuff, is I'm a member of CELCAB, and I found this great article, and I really want my other members to read it because at the next meeting we're going to discuss it, and it's really, really good. What this is saying is that you could send it to all the members, but they cannot respond back to you because that's where the conversation occurs. I do not encourage that at all. There is a better way to do that to steer clear of any type of allegation of a sunshine violation, and that would be to send that article that I found to our town clerk, and then our town clerk would then distribute it to you, to the other members of the committee. That way there is no allegation of that, oh, there was an email back and forth. They've been emailing each other. That will not occur. And our town clerk, I'm telling you, you're the star today. She is our custodian of public records. So she has the responsibility to maintain all the records of the town. And that communication, that delivery of that article, that is a public record. And we'll get into that in a minute or two. So the fact that you send it to Amy and then Amy will turn around and send it to everyone works. The other little risk area associated with, I found that article, I wanted to send it to everybody. If you send it to somebody and they like it, and unfortunately they hit reply all, that can be problematic as well because then there's interaction between two members of the same board regarding a topic that foreseeably may come before you because the whole reason of sending that article out was to generate conversation at the next board meeting. So to summarize, any one-way communication, for example, one advisory board member wants to forward an article for information, should be distributed by the advisory board office, which would be Amy, so it can be preserved as the public record and to ensure that any response is made only at a. So the recipient of that article at the next meeting, that was a great article. Thank you, Jane, for sending it. You know, that communication is fine because it's at a public meeting. Okay, so when it comes to sunshine, Facebook is not your friend. So just because it's Facebook and not emails, it still provides that vehicle for the communication between two members of the same board, something that foreseeably may come before them. So again, the bottom line is 2 or more members of the same board should avoid commenting on the same social media post if the post or the comments discuss matters that may foreseeably come before that advisory board. So I am a big proponent of not creating issues where I don't need to, because there's so many hey, Counselor King, there's so many issues that come up and that take up our time. I don't want to have to deal with trying to defend myself against some type of sunshine violation. So there's a couple things you can do just to make crystal clear that, or to remove the appearance of a possible sunshine violation. And that would be on, as far as Facebook, that bottom line, just don't respond. Because if you see that someone else from the committee that you serve on is commenting on a topic that's going to come before you, just don't do it. Hold yourself back. Now, if they're talking about something that's not going to come before you, and the example is football games or recipes or travel or something like that, okay, you can comment because it's not a topic that's going to come before you. But it can get a little in that gray area because maybe right now it doesn't look like that topic is coming before you, which would be what the test is. However, maybe 5 months from now, that topic does make it to you. And I don't think that would be a violation, but somebody could raise it, and then you're in that mode of having to defend rather than doing the good work that you do.
Nancy,
Yes, ma'am.
can I say something?
Here, to the mic so everybody can hear.
Okay. I happen to have a berm issue with the present board. They don't like it that I signed that easement, okay? And so I sent out a mailing to all the ownership except the board members to tell them the reason that I chose the berm. Was that a break? No, okay, good. Oh, good.
It's a great question because you didn't send it to your fellow board members, right? You excluded them. So there was no interaction between. One of the things, and sometimes that have not, and I'm still not dealing with this mic very well, but okay, put it in the stand. There, okay, so maybe that's better now. Now I forgot what I was going to say. It'll come back. So let's move on to the next slide. So there are some exceptions to the sunshine law. So again, with the sunshine, it's got to be done in the public. So everybody knows what you're going to be talking about, what kind of decisions you're making, what things might be influencing you. But there are some exceptions, and these exceptions cannot be made by the town council. They can't say, you as a committee, we want you guys just to go meet, but don't let the public in. They can't do that. The only group that can do that is the Florida legislature. And the exceptions that they have created are very, very limited. The one that you might be familiar with is the attorney-client one. Okay, there's no exceptions that relate to your advisory boards. Let me tell you about that one exception. That would be an executive session regarding litigation. And if you've been watching the last couple meetings, you've heard me make an announcement we're going to have an executive session on Smith versus the town of Fort Myers Beach. And what that does is it allows me to meet with the town council and talk about possibility of settlement, possibility of this is how we want to strategize to address the litigation. If we were to do that in public, we've just exposed our game plan. If you were representing the other side, you would know what the town's going to do. So it makes logical sense that those conversations for litigation would be done outside of the public. But it's not a free-for-all where when we do go outside of the public, we can talk about things that should be talked about in the public. It is very strict as far as what the legislature has told us, what we can do in these shade meetings. We call them shade meetings because it's not in the sunshine. What we can do in those, and the requirements are that we must have a court reporter present. And that court reporter is going to take down verbatim. And if we were to stray into another topic and not be talking about litigation or settlement options or strategy associated with that litigation, we would be committing a sunshine violation. So we're very, very careful about that. The sunshine law, the exception, also requires that we identify specifically who is going to be in that litigation session. It's going to be your decision makers, and it's going to be your town manager as the manager of the town and the attorneys. Nobody else. So it might be an issue where we really need to know about the financial impact. If we settle, how is that going to impact our budget? We cannot ask our finance director to come in. It is only those individuals, and we will announce that we're going to have an executive session before we even do it. And we're going to tell you everybody who's going to be in there. And then the day that we're supposed to do it, we announce again. So there's no, there's not a lack of transparency. And once the litigation is concluded, you get a copy, you can get a copy of that transcript, and you would know everything that was discussed during that meeting.
So, Nancy, with that hypothetical, it would, to me, it would be reasonable that the participants that are going to be in that meeting may want to do their homework so that they're prepared to discuss things,
Yes,
perhaps how it would impact the budget.
Yes.
So is it inappropriate for them as an individual to go and talk to the finance people ahead of time so that they know what the impact would be if this step is taken?
that would be very appropriate for them to be prepared for that particular meeting. And if you recall, it's okay to have conversations with staff because staff is not a member of your board. Staff doesn't have that decision-making power. And then you're going to say, oh, but we don't have decision-making power. We just do recommendations. A recommendation is a decision. So let's move on. So we talked about, I just went into that, about staff. So you're not prohibited from talking to staff. But here's the exception. You can't go to staff and say, you know, I don't really know how I'm going to vote on this. I'm going to use the local planning agency, the LPA, as an example. So I have this rezoning come up, and I don't really know what to do. You know, I know the town wants to redevelop, but on the other hand, it looks like it's just too big of a project to go on that parcel. And so I'm going to call the planner, talk to the planner. It happens to be Jason Green. So I call up Jason Green. Hey, Jason, listen, I'm trying to brief on this rezoning, and I'm not sure. You know, I'm just kind of torn. What do you think? Jason says, well, you know, this is your criteria, and these are the facts, and, you know, staff, our recommendation is this. Yeah, but what does everybody else think? Because I don't want to go to the meeting and be the only person that votes against it. You know, I would feel really like I'm not in step or I'm out of tune or something. He can't tell you how everybody else is going to vote, because if he did, then he's like the middleman, right? You tell him, he tells her. And then that's a sunshine violation, because of the fact that the two members of the same board have communicated. Yeah, it's through a third party, but still they've communicated. A third party like Facebook, a third party like an email. So be very careful of that. But staff is very available and willing to discuss with you, because really, the more we're able to talk with you before a meeting and discuss any issue you have, the better your meeting's going to go, because you're going to be prepared. Okay, so the meetings have to be open to the public. The location has to be accessible. We talked about that. The size has to be the size of the meeting room. So let's say I really didn't want the public to come. Maybe I would choose to have the meeting in a very small room. And then what? Then you couldn't have all these people in there, right? And that is a way that is improper. That is not what you want to do. But let's say it is a very popular or controversial topic, and all these chairs are all filled. Now, this is a pretty decent sized room. I mean, this is sufficient for purposes of sunshine. We, as the town, we may put perhaps a screen outside and have chairs outside where people could actually still be a part of the meeting, but just physically not able to be in the meeting room because of capacity issues. And as we talk about it a little bit later, public comment, if they're outside, they can still come in, make their public comment, and then have to go there. As people leave, people could come in. It works very well. So size is a concern. And you can't discriminate against or restrict access to the public. Where this issue has come up in the past in other jurisdictions has been an advisory board has maybe a subcommittee, or the advisory board themselves want to meet at someone's home. It was in a city that I worked in, and it was the beautification committee, and they were going to give an award for the home that was decorated the best for the holiday. So they just wanted to meet at a member's house, have some coffee and some pastries, and go through the applications, and, you know, kind of informal. And I said, no, you really can't do that. And they were like, what? And I'm like, yeah, you can't, because it's a sunshine violation. Why? Because members of the public are not going to know that they can go to that person's house, right? And second of all, do you really want people that you don't know going through your house? Probably not. And the size of the house, I mean, what happens if a bunch of people from the whole neighborhood come? You know, you need to accommodate that. So do not have meetings in private homes. And the other example is restaurants. A lot of restaurants have conference rooms, and yeah, have your meeting in our conference room, you know, and then you can buy lunch or coffee or whatever. That has been discouraged and is kind of prohibited under the Sunshine Law, because that means me as a member of the public, if I want to come to your public meeting, I have to buy something. And maybe I just don't have that much money. And because I don't have money to allocate for $20 or $30 dinner or lunch, whatever, I may feel like I'm excluded from that meeting. So do not have your meetings in private homes or in restaurants. Okay, so you can adopt reasonable rules to make sure that your meetings are conducted in a very orderly fashion. I think, how many do you guys have procedural rules? I know LPA has them, maybe not. So maybe you can.
Nancy, most of the committees have them. They're just very old.
Oh, okay. Well, maybe that's something you might want to talk about. But you cannot ban non-disruptive videotaping, tape recording, or photography. So this is a public meeting, and if somebody came in here with a camera, they could take a picture of all of you, because it's a public building, it's a public meeting. If they come and they come in the middle of the room and, you know, they're like in your face or something, they might be disrupting me, And at that point, I might ask them to not do that. But generally, it would be allowed. And I do want you to leave with that thought too, that the Sunshine Law and the Public Records Law, the policy behind it is transparency. This is your government. We just work for you. So it's going to be very broadly interpreted, broadly. So always remember, transparency, public participation. It's very, very important. Yes, sir.
Question.
Okay.
With the advent of Zoom technology, is there any reason if this room was not open to the public with open microphones and with screens that you could not have a Zoom meeting providing the public could sit in, participate through public comment, but still have the committee members attend via Zoom?
So that issue came up during COVID. Because in COVID, we had to close down our public meetings. And there was a lot of discussion with the then Attorney General. What do we do? How do we maneuver around the Sunshine Law? Because again, transparency, government's got to work, right? We got to operate, yet it would have been a health hazard to have people come. So the Attorney General did put out an advisory that basically said, as long as you have a quorum present of your board, you could allow for remote participation by other board members if there is a vote to allow them to participate. But it really should be for extraordinary circumstances, so that one board member doesn't routinely say, I'm a board member, but I'm never going to go to their meetings. I'm just going to call in. And they call in at every meeting. Is that the type of board member that you want? Probably not. At that point, the other members that do come to the meeting might object to that. The public. So I want to address the public. So during COVID, the public was allowed to send emails in, at least in the jurisdictions that I worked in, and the emails were publicly read, which made the meeting for the people that were present very, very long. And I think that they also allowed the public to call in and maybe use the mic as well. So with technology, it can be done, but it's not the same. It's just not really the same without having a physical person there. Does that answer your question?
Well,
And-
yes and no.
Okay, give me the no.
Could the committee, in writing the rules, write the rules that says we don't necessarily need to have a quorum to hold the committee as far as those that are on Zoom?
No. And the reason I say no is because of the Attorney General opinion that's out there that says that you have to have a quorum.
And
There's
Nancy,
no way around that.
correct me if I'm wrong, but I believe once the state of emergency for COVID lifted, that's when we lost that ability again.
Right, right. She's correct. Because during COVID, then nobody, even at the onset, nobody came to the public buildings. Yes.
As far as you know, is that something that the state attorney general might reconsider, given that there are instances, particularly with CELCAB, where we have people who are happy, they're seasonal people that are on it, but they care deeply about the town. So they're not physically here for having meetings in the summer. So we can't establish a quorum here because we don't have enough people to say, yes, we would like for them to participate via Zoom, but if we had been able to have them participate via Zoom, we'd have a quorum.
I don't think there's a way around that at this point. I mean, I'm willing to look into it, but I don't think so. Because the extreme, taking that to the extreme would be that nobody would ever show up. And again, it's a little bit different when you actually have somebody physically here, which is why I like to come to your meetings. But sometimes I am not able to. Okay, so what happens if we make a mistake and we actually violate, which maybe it's not intentional, but it could be. So the penalty does focus on if you knowingly violate, then you could be guilty of a misdemeanor of the second degree, which is still pretty serious. But if it was unintentional, then you could still be fined up to $500. So it is important that you understand the Sunshine Law and you abide by it. I will say I am not the Sunshine Police. So if I see you violating the Sunshine, I don't have the authority to really do anything about it. It is a criminal matter. I guess if it's unintentional, it's non-criminal, but the misdemeanor would be prosecuted by the state attorney's office. There would be an investigator, and then it would go through that process. So, words of wisdom, whenever I see like two people of the same committee talking, I might jump in the middle of the conversation, just so then I am a third party and I can hear what they're talking about. And if it's borderline, I might just say, hey guys, sunshine, it's sunny in Fort Myers Beach, hint, hint, right? And then they'll go, oh yeah, or a person that is a better person would be a person who is not even associated with the town, because the argument could be made, yeah, but you work for the town, so you might be biased. But yeah, have people around you. Don't create the situation that can raise issues, I guess is where I'm going with it. So is there any questions? Because I think we're now going to go into public records. Okay, public records. So public records law is embedded not only in our state statutes, it's chapter 119, but it's also in our Florida Constitution. So that it's very serious. And chapter 119 defines what a public record is. And as I mentioned earlier, Sunshine Law, public records law is very broadly construed. So look at that list of things. So it's going to be documents, papers, letters, maps, books, tapes, photographs, films, sound recording, data processing software, other materials, regardless of the physical form, their characteristics, the means of transmission, made or received pursuant to law or ordinance. And here's the key: in connection with the transaction of official business by any agency. So I can email people all day, but if it doesn't relate to town business, it gets pulled out of the category of public records. And it is a form of communication. What's missing from there are text messages, because those are also public records. Okay, so the Supreme Court, there is case law that talks about all materials made or received by an agency in connection with official business, and here's another key part of it, which are used to perpetrate, communicate, or formalize knowledge. So this is all materials, regardless of whether they're in final form, unless the legislature has an exemption. And we always remind everyone that there is no, this is really embarrassing exemption from the public records law. What would that be? That would be you receive an email and you are going to communicate back to Amy, and you send her an email and you say, man, I can't believe that they asked that. That is just such a silly question, right? That email that you sent is now a public record. And if there's a public record request made, the fact that you said it was silly or some other word is going to be out there in the public. And it could appear in Facebook, it could appear on the newspaper, it could be talked about on the radio, because it's public information. So when you write about town business, make sure that you realize that whatever you're writing one day could be in the newspaper or on Facebook. Grammar, if you're going to not capitalize Nancy and, it's just really sloppy, and that's what's going to be shown. And you've probably heard examples and instances of, things that have been discovered by public records. But remember that whatever you put in writing regarding public business is open as a public record. So email and text messages, and they are subject to disclosure in the absence of the statutory. So anything that you receive by email, text, or physical copy regarding your duties is a public record. You can't destroy them because it's a public record unless you have given a copy to Amy, because then that record is preserved. So these are some exemptions, like the law enforcement officers and other employees, their addresses, their phone numbers, social security numbers, bank account numbers, protected health information, criminal investigations, security systems, bid responses, just for a limited time, and elected officials' addresses and phone numbers. So again, this list is a list created by the Florida legislature, not by the town council. If there is a request made for a document, the document itself is a public record, but this part of that document will be redacted because of the exclusion. And when we redact it, we have to identify the statutory exemption for the redaction. We can't just say, yeah, I think that's on there. No, that doesn't work. Electronic. So it mentioned paper. So email messages that are made and received. These are subject to disclosure. So it doesn't matter if it's paper or electronic. Anything that's placed on the town's Facebook page is going to be presumed that it is part of official town business. Again, a public record. So what is not a public record? Because, we're always looking for exceptions, right? So this would be brief notes that you make to yourself. Like if you keep just kind of a log of, notes from today's meeting, but you don't share them with anybody else. You keep them to yourself. That would not be a public record. Because if you think about it, that is just a reflection of what is in your head. It is not being communicated to another person who is, a member, anybody really. So there it goes. It comes down to whether you're communicating, perpetuating, or formalizing knowledge. Like my notes for today, if I say, I think during the meeting I said this, and I send it to Amy and I say, did I say that? Did I say that during the meeting? And that is formalizing what was said at the meeting. So yeah, it's a public record. And then you might get it and say, wow, Nancy didn't remember what she said. That's pretty bad. Okay, so, and here are some exemptions. So again, you saw the list, the home addresses of the various elected individuals, partial home addresses, GPS coordinates. They apply to the spouses and children if you have kind of a safety issue, because unfortunately the world we live in today is kind of crazy. So here is some examples.
Nancy, can I back you up just a moment?
Yes.
If you do believe you have an exemption there's a multitude of check boxes, I guess, on the form. We have those forms in our office. We can send them to you, and if you send them back to us, it is notarized now, but we will redact your information if somebody asks us for it, as long as you fall under one of those categories.
So this really deals more with non-criminal cases, material that's found to be immaterial, impertinent, or sham, or unwarranted damage. There is an exception for that, and that is new law that just came into effect in July. So if you have if you have a public record in your possession and we were to ask you for it, you would need to basically give it to us. The better practice is if you do receive something that is a public record, to go ahead and give Amy a copy of it, and then that way you don't have to worry so much about maintaining it. So we're going to get into how to create a public records request, and I'm looking over at Amy because and Amy and Jason too. Jason's behind me. They have to deal with public records on a day-to-day basis because that is one of their primary responsibilities. Officially, they are the custodian of all the records of the town. So there she is, town clerk. And she's not authorized to deny a request because of a lack of specifics in the request. So Amy, I think I'm going to give you some time to talk about best practices. Okay. What do you like and what do you not like?
You don't want to know that answer.
She said, you don't want to know that answer.
So when you're requesting public records, we actually use a software program called Next Request. It's right on our website. You navigate to the town clerk's page, and a lot of the public records we get is I would like a copy of my permit or what's being built on the corner of Estero and Tropical Shores Way, or something like that. We have a lot of self-service records available to everybody. I just don't know if everyone knows how to find them. So I've tried to make it a little easier for everyone on our clerk's page. If you go to the public records tab, you can see all building permit or any kind of permits, any kind of projects that are coming up through the LPA and going to council. Code enforcement cases, you can see them there. And if that's not what you're looking for, then we have a fourth option that says, still need a public record, click here, and then all our public records, you log it into our system. Not only me is seeing them, because I get hundreds and hundreds and hundreds of emails a day. So your email, if you send it first thing in the morning, is going to be way at the bottom of the pile by the end of the day. So we ask that everyone does do the public records through this portal. So then it's not just my eyes on it. Jason sees it, Lizette sees it. We have other people looking at them too. And then you have to be as specific as possible with your record, because whatever you ask me for, that's what I'm going to go find for you. We like dates. We like time frames, between this date and this date, who an email might have come to, exactly the document you're looking for, because it's not our job to guess what you're after. You have to tell us what you're looking for. So
it kind of dovetails into the next slide, which talks about once I make a public records request, Amy she's not bound to have it to you tomorrow or 10 days from now, but she does have to provide it to you within a reasonable period of time. And that depends on the nature of what your request is. If you make a request, what's one that took a long time? All the documents related to...
we get some that'll say, we want copies of all the building permits that were issued between 1999 and 2024. That's a little
true.
big. That's going to take a while. Chances are we're not going to be able to find all those permits because we lost a lot of records in the floods during Ian. A lot of our systems went away. The equipment flooded, so we don't have a lot of paper anymore. So, and then all those old records would have been in paper. That's usually when you'll get a phone call or an email back from us and say, what are you actually looking for? Maybe we can help you narrow this down just a little bit. If that's what they're looking for, then that's their record. And more than likely, we're going to charge you staff time to do it. We're going to ask you for a deposit before we ever start pulling records for you, and it gets costly, like thousands and thousands of dollars for us to pull a records request that big.
Yes, because it's staff time devoted to that. And I will tell you that staff has been trained on the public records law. And so they know that the same training that you're getting today, they know that if they write something down about something that they're working on and they share it with someone else in their work circle or work group, that is a public record, and they know they have to retain it. They will not necessarily be sending it to Amy, otherwise Amy's office would really be huge, or her computer would. So that's within the various departments, so they know to preserve those records. Being specific really helps too, because that way we can't really tell you what you're looking for. We might think we know what you're looking for, but if you don't tell us specifically, we are not obligated to just say, yeah, that you don't want to ask for that, you want to ask for this. So, because then we become your personal research assistants, and that's really not our job. Okay, so moving on, you have to, it says in person or in writing. Nothing requires that you make the request in person or in writing. So you could make a phone call, and whoever's receiving that phone call would know, okay, they're asking me for this document. This is a public record, and then would send it over to Amy. Again, staff has been trained to know to send requests over to Amy in her role as the custodian. Okay, she can't give out information. For example, it doesn't require them to produce an employee to answer questions that you might have. All she has to do is give you the document. There are non-exempt records. But the last sentence, I want to focus on that. The town is not required to create a new record. So if you were to call and say, I want to know the expenditure for the last 5 years, the total number of, expenditure for widgets, right? Widgets, good old widgets. If we don't have a document that already has added up all those different numbers, we are not required to do that work for you. If you say you want the document from 1 year, 2 years, 3 years, we will give you the documents, then you have to total it yourself. So sometimes a document may not exist, but the data might be out there in different places. So again, we cannot refuse to allow public records. I kind of skipped over the last slide. There are records that are confidential and that are exempt from disclosure. We have a list of those, and before she releases, she knows her job. Amy's really good at what she does. She'll know that that's exempt, can't, she'll redact it or whatever. But sometimes it might be questionable, because one set of documents that are exempt from disclosure are litigation-related documents, strategy for pending litigation. And she might not be sure, so she would pick up the phone and call me and say, can I release this? And I will look at it. I'll look at the statute and make a decision and give her some advice. As part of an exemption, she has to state the basis. She can't just say, yeah, you can't do it, but she has to give the reasons why. So general rule is that records which would not be public under state law are unavailable only when there's an absolute conflict between federal and state regarding the confidentiality of the records. We have a little bit of this, but probably it will not impact you at all. If the state statute or the federal statute requires it to be closed and state is subject to the provisions, then basically we would have to keep it closed as well.
Nancy, as
Yes,
an
ma'am.
example of this one, we're going through all our FEMA audits right now, and a lot of the buildings on the island are involved with all that FEMA investigation. Everybody was, when it first started, I was getting request after request after request for the lists that everyone would talk about. Those lists are protected by federal law. So in turn, I'm not going to give them to you because I'm not going before the feds and saying why I released a record to you. Yeah, I'm just pointing to you folks here, but, so we don't necessarily restrict it, but the federal government is restricting it from us, so we send a copy of their privacy notice with the record, highly redacted. And so that's kind of what that was talking about.
Yes, and even if that document appears in another case, for instance, some of our code enforcement cases, we've educated our special magistrates. We've tried to keep them informed of what FEMA is doing to us so that when we go forward, they know kind of why we're perhaps bringing something before them. And we redact all of that information. So even if it is something that's in a code enforcement case, subject to a federal law, confidentiality, it will be redacted as well. So I mentioned before on public meetings that you can't have them in a restaurant because it imposes or it makes somebody feel like they got to buy something and maybe they don't really want to spend the money, so it curtails their involvement, their participation in local government. The same is true for public records. So if you don't want to pay for the public record because the number of public records that you're requesting is voluminous and it's going to be a couple $100s, if not a couple thousand, you have the right to make the request and come in, and one of the clerks will sit with you and you can look at the document, but you can't really take it away because it's our original. And if you do want a copy, sometimes, I guess, a nominal, like if it's 1 or 2 pages, do you charge? Or some people do, some people don't. It depends.
We don't normally.
Yeah. I mean, if it's a 1 page that you want, we'll probably just copy it and give it to you. But, because it takes more staff time to go through the process of collecting how much is it per page?
It's 15 cents a page or 20 cents double-sided, but I see Nancy making gestures like we have a lot of paper here anymore. We don't have a lot of paper, so we'd have to put it on a computer, sit down there and watch you looking at it on a computer because we have a lot of electronic records anymore.
And unfortunately, we do have to watch because if the public record disappears, then we've lost our public record, and we can't let that happen. So there is a little bit of staff time that's going to be allocated to that, and that would be the imposition of a special service charge for that supervisory inspection. Okay, so there is no fee, and I think Amy just talked about the 15 cents. Amy also has mentioned, I think she's seen my presentation already, that we can require a deposit. It would be in a reasonable amount. If you ask us for, 100 pages of something, because think about it. We spend the staff time, we make a copy of it, and you never come back. And then we're sitting with all this documents. But if you give us money and we will figure out exactly how much it costs, we'll refund you the difference. But that helps eliminate any type of abuse of that. So penalties, okay. So in addition to judicial remedies, provides that public officers, which includes advisory board members, who knowingly violate is subject to suspension or removal or impeachment and is guilty of a misdemeanor of the first degree. So Sunshine was misdemeanor of the second degree. Criminal penalties, and this is a $1,000 fine or both. And this would be the intentional destruction of something that is a public record. Okay, so now very quickly, we're going to transition over to some ethics. And the first issue that comes up sometimes is a voting conflict. So as an appointed officer, you cannot vote on something that comes to your advisory committee that is going to present a special gain or a special loss to you, something that is unique to you and does not impact any other member of the community. And this is something that you know would come to your special benefit and maybe to your boss or to a parent organization, to one of your relatives, or to a business associate. And these, it might look like it's pretty crystal clear, but it really isn't. So who are public officers? These, again, are people who are appointed. If you are an advisory board member, the voting conflict will apply to you. Who's a principal? Well, it can be your employer. It could be a client. If you're in the legal business, accounting, insurance, or other professional practice. And it could be to a corporation where you have a role as a compensated director. Who's a relative? Now this one gets kind of interesting. Father, mother, son, daughter, husband, wife, brother, sister, father-in-law, mother-in-law, son-in-law, or daughter-in-law. So there might be some other categories that are not specifically listed. And if you happen to have one of those, just give me a call and I'll try to give you some guidance on it. So this is a little bit different from the definition of relative that's in the nepotism and in the gift laws. Again, this is for voting conflicts. So who's a business associate? This is someone engaged with you in the business enterprise, regardless of the form. It could be a partnership. It could be a joint venture, which is kind of a partnership. Or any other type. So the questions to determine whether this would apply would be whether you're engaging in a common commercial or entrepreneurial pursuit, and is it current ongoing business relationship? It's something that you did in the past. The fact that you vote on it now doesn't motivate you to vote in a particular way that would be viewed as unethical. Uh-oh. Josh,
we lost connectivity.
any questions? Do we have a copy of the presentation? I can just talk from that. Oh, there it is. Okay, so what is a special gain or loss? Now this is where it can get a little bit tricky. It doesn't apply to all situations where there might be a gain or a loss, but it has to be special. And so generally this is the economic benefit, so it's money. By making this decision, are you going to benefit or lose money? And what should be considered? So what should be considered is the size of the affected party. So maybe you're part of a group or part of a neighborhood, and based on your vote, it's going to maybe hurt the neighborhood or benefit the neighborhood. So how does that compare the benefit that you receive to somebody else who is a member of that group? Is the loss or the gain actually real? Or is it something that might happen into the future? And is it just a preliminary or a procedural matter, which might not really impact? The other example is, let's say that you're part of a club and the club comes before the town and is asking the town for money, and comes to your advisory group for a recommendation. One of the factors to look at is how many people are members of that club. Is it 100? Is it 10? Is it 3? And are you being compensated by that club? And who is going to benefit from the approval of the expenditure of that money? So it's not a black and white answer. There's a lot of factors. And if you are not certain, that's when you can reach out to me and I can help guide you along. So the special gain is going to depend on the size of the class who are similarly affected. The smaller the class, the higher the chance of it's benefiting you. The bigger the class, the less of a chance that it's benefiting you. So the remote and speculative, is it remote or speculative? Again, there's a spectrum there. It's impossible, it's unlikely, even chance, likely, and certain. So if you have a voting conflict, what do you have to do? So you've called me and I said, yes, you have a voting conflict. You need to abstain from voting and you need to disclose the conflict prior to the vote. And you have to file something that's called a Form 8B. And this is a form that's put out by the Florida Ethics Commission. And it has to be filed within 15 days to our clerk. And at the next meeting in your minutes, it would be attached. Honestly, I don't think that you guys are really going to have a lot of conflicts in an advisory role, but nevertheless, it's something to be aware of, especially if there's maybe an allocation of resources to your particular committee. And then you have to publicly disclose the conflict before participating in any discussion of the matter. Okay, this is the exceptions. There's exceptions to everything, right? So the principal by whom you are retained is a public agency. You may vote. The example that I have used is myself. At one point in my life, I was a member of the Northwest Florida Water Management Board, and this is the water management board that gives out grants, right? Grants to communities. At the time, I was also a employee for Escambia County. And so Escambia County was coming to the Water Management Board to get money to do good things for the county. And as a member of the board, I could vote on that because my vote did not come to me personally. It came to my employer who represents the public. So that was one of the exceptions. And then this is for a redevelopment agency, which we don't have one here, so I'm going to skip over that. If it affects your expenses and compensation as provided by law, you may vote. I'm not really sure what that one is getting at, but if you feel like that one applies to you, let me know. We'll look into it more. So the voting requirement, so unless you have a voting conflict, you have to vote. And this gets really tricky, especially on the second part, because sometimes these votes are very, very difficult. And you can't just basically walk out of the meeting so you don't vote, because that would not be fulfilling your duties and responsibilities for the position that you were given. But there can be some really difficult votes, and unless you have a voting conflict, you are required to vote. There is another small exception in quasi-judicial hearings, which you're not really going to have, but if you are just so biased and that you cannot have an open mind and evaluate the facts before you, you could request to not vote in that situation. The example that I used for that is, let's say that you had been married and there's now a divorce and your spouse is there asking for something from your committee, and you just can't do it. So that might be an answer, because then you're not an unbiased decision maker. Okay, the misuse of your public position. So this is basically saying that you cannot corruptly use or attempt to use your position as an appointed member of your advisory committee to get a special benefit, privilege, or exemption. So the example, and I'm just going to throw it out there. Hey, I'm a member of the CELCAB committee. Can't I go park over there? I don't have my wallet. Can you just let me park there? The fact that you say you're a member of the CELCAB committee is where you get into trouble. So don't really remind people of the status that you hold. And it is a status, it is a privilege, and the town is very grateful for your work. But there is this Florida statute that we need to be aware of. The one where people have gotten themselves in trouble is getting stopped by a police officer and saying, and actually I can tell you the story because it actually happened to me. I thought you were laughing at me, Amy. Okay, so when it happened to me, I was actually serving in, I will say it, the city of Brooksville. And I was working with them as their city attorney, and we had a meeting. Their meeting starts at 7 at night, and it was a very controversial meeting. And so I live in Claremont. I probably shouldn't have disclosed that, but I do. Anyway, it's about an hour's drive on Highway 50. You go through the Ocala forest, so it's kind of dark and everything. But so here it is, like 11:45, and I'm in my car by myself, and I'm going down Highway 50. And then all of a sudden I see the blue lights, and I'm like, oh no. But on the other hand, I was like, okay, well, this is kind of good because it's really dark out there, and I'm by myself, and let's see what's going on. And so sure enough, it was a deputy sheriff who stopped me, and he's like, how you doing? And I'm like, I'm fine. And he goes, so what are you doing out here? You know, and I said, well, I'm trying to get home, officer. Here's my driver's license. Oh, so you live in Claremont? Yes, I do. So where are you coming from? Well, I was in Brooksville. And what were you doing in Brooksville? Well, I was attending a meeting, a public meeting. And he said, oh, why were you attending a public meeting? I'm like, well, because I work for the city. And he goes, oh, okay, what do you do for the city? And I was like, okay, now I got to tell him, right? Well, I'm an attorney, and I represent the city. He goes, oh, you're the city attorney. And I'm like, yes, officer. And he goes, listen, your taillight's out. And I said, are you serious? And he goes, yes. And I go, you know, hands, right? You got to show him your hands. I said, can I come out and look at it? And he goes, sure, come on out. So I come out of my car, and sure enough, my back tail light was out. And I'm like, officer, thank you so much. And he's like, it's not a problem. I said, you know, I'm not quite at the Sumter County line yet, and it's dark, and I'm by myself. He goes, yeah. I said, could you just follow me? And he goes, sure. And so sure enough, he followed me to the Sumter line and then kind of did his lights. I did, you know, my hand, and off we went. But in the alternative, what could I have said? I could have said, well, why are you stopping me? You know, I'm the city attorney. That would have been problematic. Okay? So we are privileged and very grateful to occupy the roles that we do as appointed members of our boards. So do not misuse that. The other part of it goes to, well, that's not it. I want to go back. I can't go back. But the other part of it would be that maybe you are, or this is the other example of where people have gotten themselves into trouble, has been you were given some information in your role that maybe you know that there's going to be like a project down the road, but the rest of the public doesn't know. And you call up your spouse and you say, hey, I think we need to invest in that because I think the town's going to do something there. And nobody else knows about it, but you know about it because of your appointed position. That would be also a misuse of your public position because that is information that only you know because of the fact that you're able to occupy that role. There we go. Help. Let's see. Misuse of public position. All right, we'll just do it this way. So, okay, I've got help here. This is good. I think the next one is quid pro quo. And that also goes to your privilege that you have to serve in this position. Hey, I'm an appointed member of this committee, and if you do this for me, then I'll make sure that they really like your proposal that you're bringing to us. That would not be, there you go. The acceptance of any type of thing, which could be a gift, a loan, a reward, a promise of future employment, a favor, service, but it's based on an understanding that if you do this for me, then I'll do this for you. And that's kind of a distinction. Again, there could be a little bit of a gray area there, but my advice is don't even let anybody raise the issue because we have other things we've got to get done. So you cannot accept any money, payment, or thing of value when you know that the reason that they're giving that to you is to try to make you decide something in their favor. This issue sometimes comes up when someone wants to donate something to the town and they want to donate it to perhaps one of the individual members for the town. So what we always request is that they come to a public meeting and they offer the donation to the town as a whole. I encourage our elected officials to not accept anything of value except when it's done at a public meeting. And it can go through the town manager would be the appropriate way. Okay, anything you get for which you do not give equal or greater consideration for 90 days might be considered a gift. And this includes food, beverage, membership dues, plants, flowers, floral, transportation, lodging, preferred rates, use of property, and tickets. So what is not a gift? A salary, rewards in recognition of service. It might be that the town is giving something to you. Gifts from a government officer, an employee organization. So if you get something that they're giving you something that is really intended for the town, you need to bring it to a public meeting. First of all, let the town manager know, bring it to a public meeting, and we make the presentation at that point. So the short version of the gift law is anything under $25 is pretty much permitted because of the fact that your vote on something hopefully would not be influenced by $25 or less. But if it does get to 25 to 100, then you do need to report it. And then anything over $100 is prohibited. If the value is, let's say it's $150, you could accept, I think, up to, you'd have to report it, but you could accept up to $99, and then anything over would be prohibited. And then you can receive gifts from your relatives, because hopefully your relatives are not giving you something to influence your decision making on your advisory board. So this will not impact anyone in the room today, but maybe someone who's watching online. If you are a member of the LPA, the local planning agency, or the audit committee, you do have to fill out the Form 1. The Form 1 is a disclosure form, which you basically identify the sources of your income and your assets, but not necessarily the amounts. For instance, I would disclose that I work for the Vos Law Firm. I don't have to say how much I work for or what I get paid. And now it's being done online, and there is a deadline July 1st of every year. And it's so much easier now that it's online. And I believe, Amy, you are the keeper of, you notify people, don't you, that they
Yes.
have to file a Form 1?
Yes, we do.
And when do you generally do that? Like in June? For July, or how do
No,
you do it?
when you first get appointed to a committee that requires financial disclosure, I think you have 30 or 60 days to file this form with the Commission on Ethics, not with our office. We tell you that when you first get appointed to that committee, and then every year after that, the state will send you a reminder in the mail, or I think I got mine by email this year, that every year you are required to file this form again with them.
And it is filed online. And also, when you terminate, if you are on the audit committee or the local planning agency, there's a time period, I think it's 60 days, that you need to file a form identifying that you no longer serve on one of those two committees. Okay, questions. So I've gone almost an hour and a half, and I committed to an hour. Oops. Does anybody have any questions? I know for some of you, this is just repetitive, but even for me, just to hear it again and to go through the outline, it really helps just to keep it forefront in your mind. I am available. If you can't reach me, I might refer you to one of our other attorneys in our firm. We can try to help you figure out if you're in the gray area and a resolution of the issue. You can also call the Florida Ethics Commission. They have a ethics hotline for issues related to voting conflict, gifts. What else? I think that was it. Voting conflicts and gifts. Yeah, those are the big ones. Okay. Any other questions? Oh, well, thank you. I hope I didn't ramble too much. Again, I told you I could talk a lot. So I want to thank you all for coming. And with that said, our meeting is adjourned. Okay.